in Plevin and Paragon Personal Finance Limited.
I'll ask Lord Sumption to give the judgment. 3 years ago, Mrs. Plevin successfully defended an appeal in this court by Paragon Personal Finance, a loan company which had lent her money without disclosing the scale of the commissions payable on her associated PPI policy. The decision established some important principles governing the duty of disclosure and fair dealing in transactions of this kind. Costs were awarded in her favour. This judgment is about the assessment of those costs. They were assessed by the costs judges at over £750,000. More than two-thirds of that sum represented the premium on Mrs. Plevin's after-the-event, or ATE, insurance, and another 31,000 odd represented her solicitor's success fees. The loan company has a right, which it has exercised, to ask for the assessment to be reviewed by the court. It is unusual for a formal judgment to be given on such reviews, but we are doing so in this case because the review raises an issue about the recoverability of ATE insurance premiums, which is of some general importance and may affect other cases. After the event insurance is insurance against the risk of having to pay the other side's costs if the insured loses the case. Under the costs regime, which applied between 1999 and 2013, if the insured litigant wins the case and is awarded the costs, the premium may be recovered from the losing party as part of those costs. In addition, the litigant was allowed to agree a success fee with his or her solicitors, and that too might be recovered from the losing party. The system greatly increased the financial risks associated with litigation, especially for defendants, as witnessed the facts of this case, where it had the effect of tripling the loan company's costs bill. Sir Rupert Jackson's review of litigation costs recommended that the right to recover ATE premiums and success fees should be abolished. And under the Legal Aid Sentencing and Punishment of Offenders Act 2012, it was abolished with effect from the 1st of April 2013. The problem in this case arises from the fact that the litigation straddles the cut-off date. Mrs. Plevin took out ATE insurance before the 1st of April 2013, limited to the costs of the trial. She lost in the county court and appealed to the Court of Appeal, where she won. Paragon then appealed to the Supreme Court. Both of these appeals were begun after the cut-off date. Mrs. Plevin topped up the policy twice to cover the successive appeals, but again after the cut-off date. There are transitional provisions in the 2012 Act to deal with this kind of problem. They provide, in summary, that the old costs regime will continue to apply where an insurance in relation to the proceedings is taken out before the cut-off date. The question on this review is whether, if ATE insurance is taken out for the trial before the cut-off date, a subsequent appeal counts as part of the same proceedings or as separate proceedings. If the appeals are part of the same proceedings, then Mrs. Plevin is entitled to charge the cost of the premium to the losing party. If they are distinct proceedings, then she is not. The Supreme Court rules by a majority of 4-1 that the appeals are part of the same proceedings as the trial. For this particular purpose, proceedings means the whole of the action arising from the dispute at whatever stage of the court hierarchy it is conducted. Accordingly, the top-up premiums for the appeals are recoverable as costs under the pre-April 2013 regime. There is a further and less significant issue about the solicitor's success fee. Paragon contended that it was not recoverable, first because Mrs. Plevin's solicitors were restructured twice during the litigation, and the conditional fee agreement, they say, was not properly assigned to the successive embodiments of the firm, and secondly, because like the ATE insurance, it had to be amended after the cut-off date to cover the appeals. The first is a highly technical point which fails on the facts. The second depends on a differently worded transitional provision in the 2012 Act, which makes it clear that the whole of the action is covered at every stage. Accordingly, this court confirms the assessment of the costs judges.